Friends, session number 26 of the series on military law is the lecture about procedure and challenges. This would explain the actual modalities of a trial by court-martial and different aspects on which an accused may challenge or raise a plea before the court. Starting with the special plea, if the special plea to the general jurisdiction of the court is allowed, the court would record its reasoned decision that will show application of the mind while this plea is being accepted, and then it would report to the convening officer and thereafter adjourn. On the other hand, there could be a contingency that the court is in doubt whether the special plea is valid or not. In that case, it would refer the matter to the convening authority for a decision with regard to the validity of the special plea. The third contingency is that such a plea is disallowed, rejected, then the court proceeds further with the trial. Coming to the general plea advanced by the accused, whether he is guilty or not guilty to the charge, Army Rule 52 elaborates that the accused plea of guilty or not guilty is recorded with regard to each charge. Of course, this is only there if there is more than a charge. And if the accused pleads guilty, before such a plea is recorded, after hearing him, the court shall ascertain from him, satisfy itself that the accused understands the nature of the charge and in particular to the meaning of the charge. And in case if it finds desirable, it shall also explain to the accused the general effect of that plea and the difference in procedure which will be made by the plea of guilty. And this difference is essentially that on a plea of guilty, the court is not required to call witnesses because the accused himself is accepting his guilt. Relating to other further aspects on this plea of guilty or not guilty, the court shall advise him, means the accused, to withdraw that plea if it appears to the court that accused ought to have pleaded not guilty to the charge. And this satisfaction of the court has to be recorded in the proceedings to the effect that the court is satisfied that the accused has understood the effect of his plea of guilty, and also that court has complied with the provisions of Army Rule 52 Clause 2. Army Rule 52 Clause 4 states that if the charge is such that the offense in relation to that charge carries death penalty, or in other words, it's a capital offense, in that case, the plea of guilty will not be accepted. And even if the accused offers a plea of guilty, the trial shall proceed as if he has pleaded not guilty to the charge. Then there is a plea in bar, which means that the accused, before he pleads, he can say that he has already been convicted or acquitted by a criminal court or a court-martial with regard to that charge, or he had been dealt summarily under sections 80, 83, 84 or 85, or that the charge had been dismissed. Or it can also be raised where an accused has been pardoned or the offense has been condoned, or where the limitation period provisions need to come in play and the limitation period stands expired. Now, on these grounds, the plea in bar may be advanced if the accused pleads guilty to the first of two or more charges laid down in the alternative. The prosecutor may withdraw such alternative charge. I will explain this further, that there may be that the charge framed against the accused has got two or more alternative charges. And if the accused pleads guilty to the first charge, where alternative charges are to follow, the prosecutor may withdraw alternative charges and may say that prosecution is satisfied with his plea of guilty to the first charge. On the other hand, if the accused pleads not guilty to the first charge, which is more serious, and guilty to the other charges which are relatively lenient, carrying the sentence, then the court would disregard that plea of guilty and proceed as if he has pleaded not guilty to the charge. Uh, the other contingency can be that the accused has pleaded guilty to some of the charges and not guilty to others in the same charge sheet. If this is the situation, then the trial would first proceed with respect to not guilty charges, and when that procedure is through, then it would take up charges on which a plea of guilty has been recorded. So, converse is not the true. The court doesn't start with the plead guilty charges first and then come to not guilty. It is the other way around. First not guilty and then guilty charges. And after recording the plea of guilty on a charge, if the court receives any statement which the accused desires to make in reference to the charge, it may do so. The summary of evidence would be read, and then it is for the accused that he has an opportunity to make a statement in mitigation of the sentence, wherein he can bring in his previous record of service or his family considerations, etc. The Rule 54 Clause 5 states that if from the statement of the accused or from the summary of evidence it appears to the court that accused has really not understood the effect of the plea of guilty, then it may alter the record and decide a plea, enter a plea of not guilty, and then proceed with the trial. The procedure and the contingency where accused has pleaded not guilty, the plea of not guilty would be recorded, and the accused would be asked that, look, do you want to apply for an adjournment? And this adjournment can be given on the ground by the defense that any of the rules relating to procedure before trial has not been complied with, or that accused has not had a sufficient opportunity to prepare his defense. If the court is satisfied, it may adjourn and give him time, or if not satisfied, then it may reject such a contention and proceed with the trial. And after the adjournment, or if there is to be no adjournment, the prosecutor will start his case by making an opening address. An opening address is nothing but containing the substance of the charge against the accused and the nature and general effect of the evidence which the prosecutor wishes to lead with regard to the charge in prosecution. The next stage is, after the opening address, examination of witness commences. The prosecutor calls his witnesses one by one for examination. Witnesses are sworn or affirmed. Calling of witnesses should be in a logical sequence. Accused, through his counsel, or if there is a defending officer, may cross-examine those witnesses. So examination in chief, cross-examination by defense, and then after the re-examination, court or the judge advocate, if they think necessary, they can put a question to the witness, and in the end, if the prosecutor or defense wants any further question with regard to the evidence that has come forth when the witness was responding to court questions or judge advocate questions, can be put through the court, not directly. A point about which all witnesses are to be called. Prosecutor is not bound to call all the witnesses whose evidence is contained in the summary of evidence. He may tender some witnesses. However, the defense has a right still to insist that it would like to call those witnesses for cross-examination. Secondly, if the prosecutor intends to call a witness whose evidence is not contained in the summary of evidence, then he is expected to give a gist of what this witness would say to the defense, and if such a gist is not given, then the defense may ask for time and adjournment of the proceedings so that they can prepare based on this new evidence that has come before the court, as it was not contained in the summary of evidence. Civilian witnesses can be summoned by the convening officer, presiding officer of the court martial, or by the judge advocate or C of the accused. So any civilian witness can be summoned, and the summons would be sent through the magistrate in whose geographical jurisdiction such a witness resides, and the summons shall also indicate with adequate clarity as to what is the matter for which this civilian witness is being summoned. If there are certain government officials whose evidence is necessary, then in the cases of trial for desertion, absence without leave, overstaying leave, or not joining when warned for service, accused relies in his defense, pointing out that a government servant or a government official may be able to give valid support to his contention. Then the court may send a letter to such officials, and a written reply signed by such officials shall be taken in as evidence with regard to that matter which has been raised by the defense, and for this provisions are contained in Army Act section 143. There is also a provision for examination of witness on commission, and if it appears that a witness cannot be called, there would be delay, time taken, then attendance of such witness can be dispensed and their evidence can be taken on commission. And in that case, commission is issued by the Judge Advocate General to the district magistrate within whose local limits such witness resides, and the magistrate will take down the evidence of that witness, and it will be sent to the court martial and shall form part of the proceedings of the court martial. There is a plea of no case which is permitted, which can be raised at a court martial under Army Rule 57, Clause 1, and this essentially indicates the defense contention that the evidence led by prosecution does not make out any case against the accused. If such a plea is raised, then prosecutor may address the court in response to the defense plea. Defense may reply, and if the court allows the plea, it records a finding of not guilty. On the other hand, if it rejects the plea, it may proceed with the trial. The court shall give brief reasons while giving its finding on a plea of no case, and if it finds that the accused is not guilty after the prosecution evidence, it may record its finding and announce the finding, and well, that's the end of the case. Now, a point with regard to examination of the witness and of the accused and defense witnesses, Army Rule 58. At any stage, it says that the accused may be asked to explain circumstances appearing in evidence against him, and he can be so asked by the court or the judge advocate without even previously warning the accused and put questions to him. And during such a process, no oath is administered to the accused if he is to be examined under Army Rule 58, Clause A, and the accused shall not render himself liable to punishment. He may even say that he doesn't wish to answer or reply to the court or the judge advocate, as the case may be. Then, after the close of the case for the prosecution, presiding officer or judge advocate shall explain to the accused that he may make an unsworn statement against him. And if the defense wants, it can make an unsworn statement in disproof of the charges which are contained in the charge sheet. Care is to be taken that the accused is not to be called as a witness except at his own request in writing, and if he fails to give evidence, well, that cannot be made the subject matter of any comment by any of the parties. In case if the accused gives evidence on oath or affirmation, then he shall be examined as first witness for the defense. So supposing he says that he wants to make a statement and also call witnesses in his defense, well, then first he would be asked to give his statement, followed by other witnesses, and he may also call witnesses about his character, that generally has been of a very high character. At the end of the case, for the all witnesses, when they have been examined, prosecutor makes a closing address, and followed by the accused or his counsel or defending officer is entitled to make a reply. So first prosecutor makes a closing address, followed by the accused or his defense counsel, defending officer, and where any point of law is raised by the accused, the prosecutor may, with the permission of the court, make his submission with regard to that point. Then is the stage under Army Rule 60 for the judge advocate to give his summing up, and when he gives summing up, when he explains to the court the law relating to the charges, no other address is allowed, and the summing up by the judge advocate is given in open court, where he explains the evidence with regard to each charge. What happens then thereafter is the finding of the court, Army Rule 62, and finding of the court on each charge that was framed and contained in the charge sheet shall be recorded, and it is recorded as guilty or not guilty, and the court is also now expected to give brief reasons in support of the finding, and there are also provisions with regard to special finding and finding on alternative charges, which are contained in Army Rule 62, and special finding may be if there is any minor variation, say in number of items that were made subject of theft, or if there is a difference in timing, if it is mentioned in the charge, which does not substantially affect the case. After the recording of the finding, it is announced in the open court, and if the finding is not guilty, the accused is acquitted, and finding is required to be announced with regard to each charge that is in the charge sheet. A special finding under Army Rule 139 is for conviction for an offense not charged. For example, the finding, the charge was framed with regard to, say, desertion, but the accused is able to show to the court, to make the court believe that he did not desert, it was a case of absent without leave. So the court would say that the court finds the accused not guilty of desertion but guilty of absent without leave. Now, this is an example of special finding. Army Rule 139 is in this regard. Then procedure on conviction: after accused has been found guilty, the evidence is taken about his general character, and general character is like excellent, very good, good, satisfactory, fair, and so on. About his age, how much service has he put in, his rank, if he had rendered any distinguished service. On the other hand, previous convictions, if about the length of time that he has been in custody, if he is in receipt of any military decorations, Veer Chakra or Vishwas Seva Medal and such like matters. This evidence is given by the witness who is in possession of the official records concerning the accused, and accused will be entitled to cross-examine him and lead evidence in rebuttal if he so feels it necessary. After such a stage, the court decides what sentence to be given. Accused has been found guilty, that has been announced, evidence has been given about his character, and the next stage is sentence. Court awards a single sentence in respect of all the offences for which he has been found guilty. Means that court doesn't give separate sentence with regard to each charge for which he has been found guilty, and at this stage the court may also make a recommendation for mercy, and sentence and any recommendation for mercy are also announced in the open court, and it is said, the court says that sentence is subject to confirmation. This, in nutshell, indicates the procedure followed by a district court martial, summary general court martial, and general court martial. This procedure, as you would have seen, is reasonable, fair, and it is also expedient and conducive to maintenance of discipline in the military service. Thank you.